Well, it's so nice to be here. I hadn't been in St. Andrews before, although I'd been in Edinburgh many years ago. But it's been grand looking around at the cathedral, or what remains of it, and the castle, what remains of it, and so on. What I'm going to talk about today is a topic that I've been thinking about for a long time. I'm still not sure I have the correct answers to the questions that I want to raise, but as we progress, you'll see what I mean. For about a third of a millennium, this is turned on, probably not. For about a third of a millennium, from 100 BCE to 235 CE, the Roman jurists, the juris consulti or juris parity, appropriated the analytical methods of Greek science and philosophy and applied them to the institutions, rules, and procedures of Roman law, thereby dramatically refashioning the way that law itself is understood, with enduring consequences for subsequent law in the Mediterranean and European world and in many societies elsewhere. Simultaneously, the jurists also created themselves, so to speak, as members of a distinct and recognizable profession, albeit with characteristics quite dissimilar to their counterparts in the modern world. The jurist's innovation in this respect had many aspects, but at its core were two of signal importance. First, around the relatively weak judicial system of Rome, at least the Republican system as it's called, they generated a specialist literature, specialist in the sense that the jurists developed Roman legal rules, above all by writing about them from what we might term an internal perspective in extensive works, mainly intended for other jurists, or at least legally educated persons, and not for the general public, or even its better educated strata. Second, the jurists also developed a system of legal education, at first quite rudimentary, and only very slowly transformed into an academic course of instruction, so as to transmit their expertise from one generation to the next, thereby sustaining their circle over time. Legal writing and education became hallmarks of the tradition that the jurists founded. Let's see where this works, yes. My interest is primarily in the first 3/4 of the juristic period, from about 100 BCE to about 150 CE. Let me briefly indicate why I set these parameters. The first is easy enough. At about this date, that is 100 BCE, especially with the writings of Quintus Mucius Scaevola the Pontifex, consul in 95 BCE, Roman legal thinking takes a sort of quantum leap forward, with far more sustained and comprehensive examination of legal institutions. In particular, Quintus Mucius is the first jurist known to have made effective use of the powerful Aristotelian analytical tool of definition per genus et differentiam, establishing law by grouping institutions together and then distinguishing them from one another, something that remains an important tool in modern legal thinking. In addition, he appears to have established the characteristic form of juristic casuistry, stylized hypothetical cases of the form, if a tree trimmer threw down a branch from a tree and killed a passing slave, which provided the jurist with a mechanism for discussing and developing law, often over centuries, a valuable mechanism, especially in the absence of appellate courts and reasoned opinions, since it insulated jurists from the fact-rich environment of actual cases. The end point of my time period is more difficult. Around the middle of the 2nd century CE, that is roughly during the reign of Antoninus Pius, 138 to 160 CE, with the juristic identity and authority now well established in the area of Roman private law, largely the law between private individuals, there occurred a series of significant changes that usher in the final phase of the juristic movement. But it is generally difficult to date these changes much less to establish their causal interaction. These changes include the freezing of the praetor's edict, private law's main procedural guide, in the addition by the jurist Julian under the Emperor Hadrian, and in consequence, the jurists' increased emphasis on developing the law through interpretation of the edict rather than through procedural innovation. The introduction by Celsus, Julian, and others of the digesta form of legal commentary, which accompanied traditional exposition of edictal commentary with lengthy treatment of selected imperial statutes, a sharp increase in the apparent rate of citation of imperial rescripts that both settle previously contested law and make significant innovations, the emergence of formal legal education with Gaius, Florentinus, and others, the composition of juristic treatises outside the traditional boundaries of private law, for instance in administrative, military, tax, and other forms of law, the appearance of jurists who, from their preserved fragments, appear to have avoided private law altogether and published only in the new areas of law that the jurists were colonizing. The rapidly increasing absorption of jurists into the imperial bureaucracy, including its legislative, administrative, and judicial branches, and that word has to be used loosely, through the creation of a non-senatorial equestrian career path, and over against the traditional republican courts of the the urban praetor, the spread and quickly rising salience of imperial courts with their distinctive procedure called cognitio extra ordinem, and modes of review and appeal reaching finally to the emperor. And finally, the spread of Roman citizenship, and with it Roman legal culture, into geographic areas above all the Greek East, not previously dominated by Roman private law. While I am reluctant to place too close-fitting an interpretive jacket on these diverse developments, and I am certainly not suggesting any significant breach in the juris-accretive development of private law, my strong sense is that what underlies the larger systemic changes is a more or less conscious decision by the imperial government once and for all to abandon a general laissez-faire attitude toward the legal profession and instead to begin making much heavier use of its highly developed skills in the governance of the Roman Empire. My interest, however, is in the long, long period, 2.5 centuries, that precedes these important late developments. Here there is what I believe to be a major problem in our understanding of the development of Roman law. I advance notice of this problem somewhat tentatively, since it has gone almost totally unobserved among Roman legal historians. Therefore, I would have to admit, at the outset, it may not be much of a problem at all, but simply the artifact of an overactive academic mind. Assuming for the moment that I am, or at least may be, right to detect this problem, I'm going to require a bit of time to explain it. And some of what I have to say will undoubtedly go over ground that may be thoroughly familiar to many of you. Please bear with me because my argument involves looking at this evidence from a possibly unfamiliar perspective. We may begin with the next slide. By looking at 3 broad characteristics of the entire of the early and high classical period, from the late Republic to the mid-2nd century CE. These characteristics are, first, a strong tendency of jurists in this period to pursue political careers in the Republican magistracy, which culminates quite commonly both with Senate membership and the consulate. Second, an unexpectedly weak structural relationship between the law that the jurists developed and the law applied in traditional Roman courts. And third, that Roman legal writing, to the extent that it reflects actual juristic practice, is notable for a considerable degree of persistent, unresolved disagreement among the jurists, with a striking lack of mechanisms to settle disagreements in the interests of legal certainty. My argument will be that these 3 characteristics are fundamentally interrelated. First, it is well known First, it is well known that the early imperial jurists were usually members of the upper classes, and that indeed many of them were senators who attained the consulate, the highest Roman magistracy. Wolfgang Kunkel's classic analysis of their social position found 41 jurists in the period from Augustus to the mid-2nd century. It's a long period of time, a century and a half. 41 known jurists, of whom a minimum of 12 and a likely maximum of 18 were consuls. These include a large number of the jurists who had considerable influence on the later juristic tradition, including Cocceius Nerva, grandfather of the emperor, Cassius Longinus, Euvolenus, Naratius, Celsus, and Julian. Two others probably reached the office next junior, that is the praetorship, and one of these, the very eminent Antistius Labio, chose not to advance beyond. Only one jurist, Masurius Sabinus, is known to have remained an equus in the equestrian class, still an indicator of social privilege. Although we are left with 20 whose standing is uncertain, the majority of them are not unlikely to have been senators as well. A few of these 20 are important in the later tradition, but most are mere names, with few, if any, legal attestations. There are many implications of the jurist's high social standing, but one has perhaps not been sufficiently observed. The jurists of this period were, as the Emperor Hadrian tartly observed, self-appointed legal experts with no formal credentials required, only a talent for law recognized primarily by their peers. But a senatorial career itself was extremely demanding, as can be seen from the few surviving inscriptions that detail the offices of known jurists. No, that's not working. This honorary inscription from Dalmatia, for some reason, lists only the provincial offices of Euvolenus, while somewhat anomalously omitting his civil offices at Rome, which must have included a consulship. It shows duties in the provinces of Dalmatia, Britain, Upper Germany, Syria, and Africa, that is to say, spanning the entire empire. All of these offices would have involved handling administrative matters, including the conduct of trials. The array of experiences involved is matched by Pliny the Younger's description of Euvolenus's duty as an official counselor and legal advisor at Rome. An inscription for Julian, and I'll have to bring this up. An inscription for Julian from his home province of Africa, or what's likely to be his home province, displays a similar array of demanding offices both at Rome, culminating at a consulate in 148, and in the provinces where military posts are intertwined with governorships. Balancing such a career with deep thinking about the law was surely arduous. The inscription notes that the Emperor Hadrian doubled his quaestor's salary because of his signal knowledge. Even the obscure jurist Pactymaeus Clemens, consul in 138, known from a single citation in Justinian's Digest, but celebrated as a juris consultus in this honorary inscription from Numidia, had a likewise extensive and civil and military career. Even for jurists who did not pursue a political career, such as Titius Aristo, life in the capital could be extremely busy. His friend Pliny the Younger describes Aristo's immense knowledge, constantly at the service of others, and I'm just going to quote from the translation. He does not haunt the training grounds and the public porticos, nor does he claim the idle moments of others by indulging in long talks. No, he is always in his toga and always at work. His services are at the disposal of many in the courts, and he helps numbers more by his advice. Much can be, and actually has been, written on the relationship of the jurists in their professional lives to imperial power. It is undoubtedly true that the development of jurist law was to a large extent informed by their wide and deep administrative experience, and the jurists' legal capacities simultaneously advanced their careers as governors and advisors. The only caveat is to avoid exaggeration in this respect. Within the arcane structure of the Roman Principate, law and lawyers carried far less weight than in modern states. In any case, my point is a simpler one. Roman law was not a full-time occupation for the jurists, not remotely like it is for most lawyers today. The pursuit of private law blended complexly with their lives as powerful, intelligent, and highly experienced statesmen. In no sense were they academics. And yet they found time to write voluminously. In Julian's case, 90 books of digesta, plus 10 more of commentaries on 2 prior jurists, works filled with intricate analysis of legal problems. Anyone who spent weeks on end untying the knots in Julian's analogies will come away with an appreciation of his extraordinary ease in handling legal materials. But despite the obvious devotion of the jurists to their craft, they received no direct compensation for their work. Luckily, most came from wealthy families to begin with, and their practice of law resembled, to speak in modern terms, less a vocation than an avocation. This brings me to my second characteristic. The inadequate hold of jurist law within the traditional lay-staffed judicial system of Rome. By chance, we can measure this hold both at the beginning and the end of the period I am discussing. At its beginning, in the later Republic in 69 BCE, I'll give you a translation of this in a second. The orator Cicero lays out an argument for why lay judges must accept and apply the opinion of jurists on matters of law. In a long passage where, owing to the exigencies of a particular trial, Cicero vigorously upholds the authority of the jurist. Elsewhere, to be sure, he is much less favorable and often outright derisive. He contends in brief, here's translation. He contends in brief that judges must follow the opinion of the jurist when the jurists correctly state the law applicable to a given case. There's a bit of argumentative daylight here in that Cicero also allows for the possibility that the jurists might be collectively wrong in error about the law, although the presumption is clearly on their side. If the jurists disagree with one another as to the law, Cicero continues, then a judge has the option of selecting the view that seems to him best, but may not then just devise a rule on his own. This position, at such an early date, almost entirely aspirational, obviously opens the way to a bit of jurist shopping when juristic disagreement is present, and we have evidence for that from the late Republic. Over 2 centuries later, in a famous passage from Gaius's Institutes, around 160 CE, Gaius indicates that in the meantime there had been progress, but only modest progress from Cicero's best case argument. As he says, and this is just from the translation, the responses of the learned, that's the jurists, are the determinations and opinions of those to whom it has been permitted to establish law, jura condere. If the decisions of all of them should converge, that which they so decide acquires the force of a statute. But if they disagree, a judge, a iudex within the Republican system, may follow whichever decision he wishes, and this is indicated by a rescript of the deified Hadrian. The difficulties in this passage are notorious. They stem most probably from Gaius's misguided struggle to compress the history of juristic law finding from the individual grant of imperial authority represented by the jus respondendi of Augustus, clear down to the practice of his own day. Modern discussion has been endless, but my own interest is narrower. I will take this passage at face value as establishing that as late as the reign of Antoninus Pius, when Gaius was writing, 138 to 160, emperors were still singling out privileged jurists, a task that became even more pressing at a time when the title jurisconsultus had spread outward from Rome to the municipalities and provinces, and that their writings, not just their responsa in individual cases, had by this date become, at least aspirationally, binding on judges in many instances. One aspect of this passage is central to my argument. Gaius alludes to an otherwise unattested rescript of Hadrian as having indicated a relationship between Roman jurisprudence and the law as applied within Roman courts. The Latin verb significo, an unexpectedly weak one, is frequently mistranslated by Romanists as declared or made known or the like, which quite changes the meaning. When the privileged jurists disagreed amongst themselves on a legal question, the discretion of a iudex on this question was constrained to the extent that he had to accept one from the various positions taken by the jurist. He was not free, for instance, to arrive at a legal solution of his own devising. There is at this date obviously no external process to determine a prevailing juristic view, no law of citations. However, when the jurists had ultimately reached agreement on the solution to a legal question, that is, should their positions happen to converge, then the iudex no longer has discretion. He must follow the shared position, since it acquires the force of statute, leges vicem obtinet. In this limited sense, the jurists are permitted to establish law, jura condere. How much of this was in fact indicated in Hadrian's rescript is in the state of our evidence impossible to know. But if Gaius is correct, it would appear that Hadrian's rescript went beyond the ius respondendi of Augustus, so as to acknowledge and even to strengthen the binding force of juristic opinions within contemporary courts. At the same time, it should be emphasized that this rescript accepts the reality that the jurists may not, in fact, agree amongst themselves on legal questions. It offers no direct internal or external incentive to their achieving unanimity, apart from their ensuing ability to exercise decisive influence on the outcome of trials. If the stress that I am laying on significatur is justified, in short, Hadrian did no more than tie the privileged Roman jurists more definitely to the courts. But this is potentially no insignificant change, since by apparent imperial decree, juristic decisions and writings now had an obligatory force running beyond a particular case in which a responsum had been given. The immediate question that arises from that passage of Gaius is how frequently the jurists disagreed. But there is now broad consensus among Roman legal historians that the Roman jurists very often disagreed with one another, the frequency of such divergence being only thinly disguised in the digest by the eagerness of Justinian's compilers to resolve juristic disputes whenever feasible. Of course, such disagreements among legal professionals, as I assume all of you know, is not at all uncommon from an historical perspective. What is more extraordinary is the willingness of the jurist to carry on such disagreements over centuries without a clear resolution. So let me give just one example of this. From Gaius, this is the Latin, I'll give you the translation in a second. For the civil delict of theft, Roman private law provided a far more severe financial penalty if the thief was caught in the act, so-called furtum manifestum. But what does it mean to be caught in the act? And according to Gaius, jurists had advanced 4 distinct positions. A theft is manifest, first, if the thief is apprehended while the theft is occurring, or second, while he is still in the place where it occurred, or 3, up to the time when he reaches his destination with the stolen object, or 4, if he is simply seen at any time with the stolen object in his hands. Gaius states that the 4th and broadest view has been rejected, and then the third one is evidently disapproved, non videta probari, because it is vague as to its timing. That either of the first two views is approved, although more jurists prefer the second. But it is the supposedly discredited third position, previously advanced by Sabinus, that is still maintained 2 centuries after Gaius by the late classical jurist Paul, and also ultimately approved by Justinian, albeit within strict time limits. As Romanists will recognize, this example is by no means unique. Many of these questions were never formally settled until the 50 decisions made by Justinian in 530 to 531 during the preparatory stages for the digest. Nonetheless, disagreements still mark almost every page of the digest. In a moment, I'll return to the environment in which this high level of disagreement was maintained. But first, it deserves notice that the jurist problems with the courts were actually much deeper. As the late John Crook and others have maintained, within trials, the jurists faced long-lasting and surprisingly successful resistance from rhetorically trained advocates, whose training manuals battled the notion that an external authority, such as the jurist, could be decisive in determining the outcome of a lawsuit. As I have argued elsewhere, it may have been only with the rise of imperial courts, and therefore with the overt assistance of imperial magistrates and the emperor himself, that the presumptive primacy of juristic law was finally attained, although imperial rescripts and other legislation also became then more salient in the transition to late classical law. Before this transition, it seems reasonable to hypothesize, despite our ignorance of practice in Roman courts, a slowly increasing acceptance of the jurist, to be sure, but not yet a final and conclusive victory. If this hypothesis is correct, it helps to explain some aspects of our preserved sources. For instance, the jurists, although they examine many aspects of substantive law and also of procedure as it pertains to the praetor's court, are notoriously reluctant to intrude overtly into the conduct of Roman trials. Thus, juristic sources, at any rate as preserved, have astonishingly little to say about crucial issues of civil procedure, such as burden of proof, presumptions of law, and especially the handling of testimony and physical evidence, all these being matters that seem to have been traditionally reserved for the discretion of judges as formed through rhetorical argument. Even the law of damages for breach of contract or for delict is poorly preserved, poorly developed. Of course, it is possible that some intrinsic bias in the preservation of sources could be responsible for this lack. For instance, the Digest compilers stripped out a great many references to civil procedure because the Republican courts had disappeared by the later empire, but the pattern still seems too consistent to be just the result of compilation. Finally, it is not my contention that the jurists themselves were indifferent to the continuing rhetorical influence on the conduct of trials. Indeed, our limited evidence indicates a continuing involvement in the courts, and they may have well have appreciated the back and forth of advocacy as providing them a deeper social understanding of the consequences of their decisions. The discontent I have diagnosed, however, lies elsewhere, in the jurists' ultimate inability to assume definitive control over substantive rules of law, so long as they remain formally detached from the traditional process for adjudicating civil claims. This brings me to a third characteristic of jurist law during the early classical period, a conventional structure of argument that is, certainly by the standards of modern legal scholarship, remarkably polite, almost mannerly. In light of the very high level of disagreement among the jurists, this rather bland mode of discussion might well seem paradoxical. And indeed, it is this significant discrepancy that brings me close to the problem that is central to this paper. Juristic modes of discussion have been faithfully described. For a long time, they were just almost simply ignored, but they have been faithfully described in a recent book by Professor Mario Bertone, building on an important earlier article by Andreas Schwartz. When a disagreement arises, jurists, here we go, this is the vocabulary, jurists commonly refer to it as a quaestio, an inquiry, or dubitatio, uncertainty. The most common corresponding Latin verbs, which are also heavily used, are quaeritur, a question has arisen, or dubitat, it is uncertain. For subsequent juristic discussion, the mild word disputatio is also occasionally used. Voided, by contrast, are a wide range of more forceful Latin words for disagreement, such as altercatio, discrepatio or discrepantia, discidium, discordia, dissensio or dissensus, urgium, rixa, and especially controversia, which is never used of juristic disagreements. Roman jurisprudence thus allows for a considerable degree of legal disagreement and resulting uncertainty, but not for jus controversum, at least formally not, a phrase commonly used by contrast in rhetorical writings to indicate discretionary as opposed to statutory law. This from the perspective of contending advocates. There's every reason to believe that this etiquette was very old, that it went right back to the beginning with Quintus Mutius Scaevola, who is paraphrased by the antiquarian Aulus Gellius concerning a disagreement between his father and other 2nd century BCE jurists as to the meaning of the future perfect verb in the wording of the Lex Atinia. Does the Lex Atinia's phrasing, what will have been stolen, subructum erit, let the original title to this thing be permanent, mean that the law has retroactive effect? The terminology of this report, quaesisse dubitaseque, is identical to that used in later juristic reports. In many passages where a quaestio is raised, there follows a brief and usually rather neutral description of the disagreement, usually without report of extensive argumentation. The initial query remains open until the jurists ultimately reach a degree of consensus as to the correct answer, at which point, most commonly, the verb used is constat, it is agreed, or satis constat, it is sufficiently agreed. Other formulations are, for instance, fere convenit, the general view is, or it's almost agreed. That's what that one is my favorite. Magis placuit, or plerisque placuit, most jurists have held, or maxime placet, there is widespread agreement, and so on. What such wording suggests is a process whereby juristic opinion might gradually converge on the one answer deemed preferable. Within the juristic community itself, there is no evidence for any recognized mechanism, such as organized open discussion or voting, in order to obtain, or at least to facilitate, juristic consensus on such an answer. In the absence of such mechanisms, one might anticipate that the jurists would have informally relied on the relative authority of those advocating a contested position. But although authority is doubtless tacitly invoked when a Celsus or a Julian is cited, express use of auctoritas, juristic auctoritas, apparently occurs only in Republican jurisprudence. Further, in their evaluation of disagreements, it is not clear what criteria the jurists used when they moved to consensus, by preferring one answer over others. In some passages, especially toward the end of the classical period, a jurist praises a rule as preferable on grounds of its greater fairness, aequius, or liberality, benignius, or practicality, utilius, but no clear scheme for choosing can be discerned, or has been discerned. Here, Professor Bertone is helpful in pointing to isolating one commonly repeated phrase, namely that a particular answer to a legal question is considered truer, various than others. Pomponius, in this passage, gives a nice example. In rejecting an opinion of Labeo and Sabinus in favor of Proculus, he He describes the latter's view as truer, varius. In translating the Latin, the temptation is irresistible to render varius as more correct, so the Watson Digest, or most correct, so the Dutch translation. But Pomponius appears to go even further, beyond correctness, to a standard of actual truthfulness. Still more startling are texts like this one from Iavelinus, and there are many others actually. Labeo had held that a woman's debtor, who had formally promised her future husband that he would provide her with a dowry, is no longer liable on the promise if the woman herself then sues the debtor on his debt. But Iavelinus describes Labeo's position as false, falsum. The precise meaning of truth, veritas, or falsehood, falsitas, in relation to a contested legal rule is of course difficult to decipher. But it may seem at first sight to accord ill with the relaxed mode of disputation that the jurists favored. As Bertoni observes, apparently a rule's truth is related in the jurist's minds to its intellectual coherence within a larger legal framework called the ratio juris. Bertoni notes that a jurist's modern colleague would say that there is no need to associate the idea of reason with that of truth, and that a juridical decision is reasonable not because it's true, but because it can be justified by the best reasons. The jurists, however, appear to have seen the matter otherwise. They seem to have thought of their law as possessing an inherent, almost scientific truth against which suspect legal propositions could be tested. For this reason, and despite their disagreements, they apparently never entertained the possibility that a legal problem might have more than one right solution. Again, this mode of juristic thinking is very old, found already in Quintus Mucius Scaevola. The leisurely pace of Roman jurisprudence, while it may be a little more than a facade, is one clear marker distinguishing it from modern legal writing. As I once wrote, Roman juristic writings are characterized by the absence of surface urgency, of any clearly expressed sense that law jobs cannot be put off until tomorrow, and the society stands in pressing need of new rules and new legal institutions. Instead, page after page is filled with a dry, rather unrhetorical prose that for the most part simply declares the law, offering no intellectually sufficient explanation or justification. Arguments are not common, and when they do appear, they seem to conceal more than they disclose about the foundation of juristic decisions. It seems probable to me that this Roman juristic culture of argument was originally shaped not so much by an internal malaise as by the persistent inability of the jurists to guarantee that their rulings would reliably, or perhaps even predictably, prevail in settling questions of law arising during actual Roman trials, at least in ordinary Republican courts. And the reason for this inability is most likely to have been the entrenched and continuing resistance of rhetorically trained advocates. This was an old fight, going back into the later Roman Republic, and we have, I think, considerable reason to believe that the fight endured long into the empire. So we come to my central question. Why is it that the oversized egos of the great classical jurists appear so domesticated in their specialist writings, as these are known to us from the Digest of Justinian and other sources? This is a phenomenon that can scarcely be duplicated in all later eras of the Western legal tradition, when the great scholars of law, certainly in my country, struck the public stage like so many self-aggrandizing, quarrelsome aristocrats. What held Roman law together? 2 centuries ago, Carl von Savigny, taking the Digest sources at face value, famously described the jurists as fungible personalities. That is, wholly substitutable one for another. More than a century later, Fritz Schultz found that view exaggerated but he still proposed to think of them as culturally opposed to individualism. Over the last 50 years, however, that view has steadily eroded and is now in full collapse, with Aldo Schiavone's vast project enlisting numerous scholars to study the juris as individuals. And some of the books in this project have already appeared, but there are a great many more planned. And Dario Mantovani's recent book on the juris as writers has also set the jurists more solidly within the broader intellectual world of their times. This is a very important book, by the way, hopefully soon in English. What I am getting at can become clearer if we look a bit more closely at some crucial sources. Earlier, I quoted a passage from Pliny the Younger's letters in which he describes Iavelinus's busy public life. But Pliny's real subject in that letter is an extremely rude remark that Iavelinus let fly during a public reading by Pescennius Paulus, an obscure Roman poet. These readings were semi-sacred events for Pliny, and Iavelinus's rude intervention led Pliny to question his mental health. On a different front, the famously irascible jurist Celsus does not hesitate to dress down an imprudent questioner, as in this famous fragment where a question is described. I put the full translation of this passage down below, and just the relevant portion in Latin up above. As in this famous fragment where a question is described as truly fatuous and silly. Yet if we move to other fragments in which Celsus is rejecting the views of his fellow jurists, his tone is quite different, far more muted and respectful. In general, juristic outbreaks of contempt are rare, very rare. One example is this fragment, which considers whether a tenant whose furnishings have been seized and slaves, the landlord has seized for non-payment of rent, can still manumit his slaves. The eminent jurist Nerva's coarse physical solution to the question of law, namely that he could shout through a window, was openly mocked, obviously by other jurists. But such passages can be counted literally on the fingers of one hand. The dangers of unleashed personality, however, are clearly are well represented in the quarrel between two leading jurists under Augustus, namely Antistius Labeo and Titius Capito. Our sources trace the quarrel to a variety of factors: methodological, political, and personal causes. But whatever the explanation, the consequences were grave. An actual rupture, as subsequent jurists divided the juristic community into two opposed camps, the Proculians and the Sabinians, with differences on a range of legal issues that today are difficult to treat systematically. It took more than a century before this divide was finally bridged. Think of personality as a centrifugal force that, unless counteracted, acts to tear the community apart in Roman times just as now. What then was the counteracting centripetal force? What held Roman law together? Let me suggest three possible answers. First, it could be that the jurists were preoccupied with the intellectual opportunities offered by the chance to develop Roman law, the intricate puzzles that arise out of legal rules, and that to this extent they learned to temper their disposition to controversy. Second, it might also be that they saw advantages, both social and political, in presenting to the world a facade of tolerance, reason, and dignified calm. Both of these solutions seem to be possible, but probably too weak in themselves to be wholly satisfactory as explanations. Therefore, I want to turn to a third explanation, which will carry us into the world of legal sociology, and particularly into the views of the late Niklas Luhmann. Although Luhmann's prolific writings are well known, if not notorious, for their intricacy and abstraction, I believe they may have considerable potential when applied to Roman legal history. However, I will deal with only one important aspect of them. One of Luhmann's primary interests was in understanding the numerous social systems that predominate in the modern world. Not only law, but politics, the economy, science, religion, education, art, and so on, each operating within its own particular environment. His inquiry centers on a central problem with these systems. In the case of law, for instance, it is now widely agreed that the law is neither entirely autonomous, in the sense that its rules are conceived without relationship to its environment, nor entirely derivative from its environment. Rather, it is in some sense relatively autonomous, neither wholly independent of nor wholly reducible to political, economic, and other social processes. But what exactly is meant by relative autonomy, that oft repeated but fundamentally ambiguous phrase? At this point, Luhmann makes a move that is extremely counterintuitive, but turns out to be surprisingly helpful. He conceives of social systems like law as existing independently of the consciousness of human actors, and this is so no matter how deeply those actors may be psychically involved in the ongoing operation of the system. Essentially, Luhmann abandons the traditional trilateral relationship of communication, sender, message, recipient, that we have inherited from ancient rhetoric, in favor of a more difficult view that it concentrates only on messages that occur within a given system and that conform to the system's expectations. In the case of law, we may think of a huge variety of relevant written and oral communications, especially orderly communications, including statutes, briefs, depositions and affidavits, testimony, forensic and appellate argument, judicial decisions, restatements, doctrinal writings, contract, deeds, wills, and so forth. The format, analysis, and substance of these and other similar communications are shaped by the legal system in which they remain embedded, and which they in turn help to shape in the future. Their composition is, as Luhmann remarks, extraordinarily demanding. On the other hand, legislative speeches, newspaper editorials, public opinion polls, and so on, even when they directly concern law, are not legal communications, but rather part of law's environment. But Luhmann is not making a value judgment here. As he repeatedly underscores, law simply could not exist, except perhaps in some theoretical sense, without its environment, which provides it with continuous input from both from society in general and from other social systems. And in return, the legal system relates to its environment as information and a resource. However, the distinction between systems and environment is nonetheless, in Luhmann's terms, fundamental. As he puts it, systems can only communicate about their environments, not with their environments. All of Luhmann's thinking on this subject remains strongly non-traditional and counterintuitive, but if his propositions are accepted, a number of important consequences follow rather easily. First, it is communications themselves, with their emphatic formal dependence on prior communications and their influence on subsequent ones, that provide the basis for law, like other social systems, being able to replicate itself over time through a process called autopoiesis. Second, within the framework of the social system, it becomes possible to grasp more exactly what is meant by speaking, as most scholars do today, of the relative autonomy of law, neither wholly determined by some other sphere, such as politics or the economy, nor wholly self-determining and immune from external influences. Third, and perhaps most important, Luhmann is able to construct a theory of social evolution occurring in and through communication as the three-step process of variation, new communications introducing disturbance into a system state, often by incorporating environmental information, selection, the positive or negative selection of specific variations, and restabilization, the state of the evolving system after selection has occurred. This provides him with a powerful analytical tool to account for historical change and contingency without either endangering the system's identity over time or relying on a reductionist theory about driving forces or a teleological approach. Turning back to Roman law, we should now be able to see many of its characteristics in a new light. In particular, with regard to legal autonomy, many Romanists, among them Fritz Schulz, once took juristic writings at face value and described the spirit of Roman law as in fact internalized and entirely isolated intellectual creation. However, this position has long troubled me in light of Roman law's historical influence as a body of law, and I have elsewhere argued that the theory of autonomous law, to the extent that it is articulated in juristic writings, actually served as an ideology articulating the border between legal and rhetorical conceptions of justice. Be that as it may, Luhmann's sociological theory encourages us to consider the impersonality of juristic writings from a perspective oriented less to the jurists themselves and more to the self-imposed systematic requirements for communication within Roman jurisprudence. Certainly, such a reorientation is strongly favored by the persistence of this highly artificial form over centuries. In Luhmann's view, the psychic motivations of those who make statements within a system or of those who receive and interpret these statements are largely unknown and unknowable, and in any case irrelevant to the legal system itself, where the principal issue is whether variations should be rejected or accepted and integrated. This communicative distance is, in fact, a dearly won achievement. Whether by evolution or accident, late Republican jurists happened upon a pattern of communication that, on the surface of its text, seemed modest and non-argumentative. Subscription to this form of communication required a good deal of self-restraint from its participants, but led to a strong and enduring profession. Autonomous law, as I've suggested elsewhere, it was largely an ideology meant to provide cover for the profession in its earliest stage. The ideology was undoubtedly of some importance to the jurists in explaining the relationship between their work and the political, economic, and social environment. But the relative autonomy of which I have been speaking is something entirely different, a pervasive internal constraint that enabled disciplined communication by professionals while constraining the explosive tug of their personalities. Insofar as the jurists are concerned, our texts are Roman law. Finally, let me stress how important this issue of autonomous survival was. Law is the only learned profession that can accurately date and document its origins as an intellectual discipline. By about 235 CE, when the active juristic community at Rome appears to have gone into dormancy, there had grown up below the level of the jurists in the capital city a large pool of legally educated persons, including local jurists, notaries, legally educated advocates and judges, administrators and bureaucrats, and law professors, as well as hierarchically organized courts and formalized legal education programs spread throughout the empire. A considerable number of persons invested in the profession and able to carry it forward even as the Western Empire eventually disintegrated and the Eastern Empire arose to take its place. By 235, the juristic form of law had probably outlived its usefulness, although its substantive law remained as a source and inspiration for later ages. Thank you, that's it.